requirements than a lot of people think. So we're going to talk through that today. But before I get started, I just want to talk about a couple of quick things. So next week, we actually aren't going to have our webinar at the normal time or at all because it's a holiday week. So just with holiday plans and everything like that, we figure it's probably best to just let people have their time off. And then our following week is going to be our in-person public seminar. So you can sign up for that at estateplanninglive.com, and then we'll know that you want to attend and you'll have a spot. And then we will also be sending out a feedback form at the end of this webinar, where you can let us know if you have any feedback, of course, but it also gives you a place to let us know to reach out to you if you'd like for an initial consultation to be set up. Those are complimentary. We do schedule them for 2 hours, so give us enough time to go through the situation. So whether it's related to probate issues that you have, or just getting your own estate plan in place, or just concerns about your current estate plan, that's a good use of time for you to utilize those initial consultations. And again, those are complimentary. So if you'd like us to reach out to you, please fill out that form that we'll send you at the end of this. So just kind of getting into what a personal representative actually needs to be aware of when we're talking about probate or, after a loved one's passed. I guess to start, well, what even is a personal representative if you aren't familiar with that term? A personal representative, if you're familiar with the term executor, is exactly the same thing. So the kind of old term for what a personal representative is an executor, and that's the person named in the will who is nominated to kind of handle the administrative decisions of the estate, the bill paying, the distribution of assets, all of that. So a personal representative is what it's commonly referred to as now. That role is referred to as now. Versus executor, but you'll sometimes see those kind of used interchangeably, and that's because they mean the same thing. So I guess what you need to know in this role is first and foremost is whether or not you're even nominated in that role. I think one of the biggest mistakes people make when they nominate somebody, whether as an initial nomination or as a backup option, is they don't actually tell the person they've nominated, oh, hey, I've named you here. And the reason this is really important to know that you're nominated is because if you don't even know that you have to do anything, you might not think to go look for the will, you might not think to file anything. So it's just knowing that you're nominated is the first step to actually act, because you need to have access to certain documents in order to actually begin acting. So this is more, I guess, what the person creating the will needs to know than the personal representative themselves. But if you've nominated somebody as a personal representative, you should tell them that so that they know that they need to look for the will. So now, if you are that person who's been nominated, you're going to need to know where the will is located. And that's because as a personal representative, you don't actually have immediate authority to act just because you've been nominated. You being listed in that will is not what automatically gives you authority to access accounts or pay bills or make decisions for the estate. So just because you're nominated it does not mean you're actually approved to act in that role. So in the meantime, after someone's passed away, before that person is actually approved to act, they don't have access to any accounts that are part of the estate. They don't have, authority to make decisions. So in the meantime, some accounts are going to be frozen and you won't be able to pay bills. Now that sounds scarier than it actually is, and I'll explain why in a minute. But it is scary to think, well, those things are frozen and I don't have access to these accounts. So when I say it's a nomination to act as a personal representative, when you're put in somebody's will in that, that order, the issue is that it is a nomination. It is not an approval. It requires court approval. Specifically, the will has to be filed with the court. It'll have to open a probate. And then when the will is initially submitted to the probate process, they will give public notice to all of the people who are inheriting under the will, or not public notice, direct notice to the people who are inheriting under the will, and then the people who would have inherited if this will were invalidated. So what that essentially means is if you've disinherited somebody from your estate, in your will, that person might still be entitled to receive notice that, hey, this is happening. This person's been nominated as personal representative. So if everybody signs off on that approval relatively quickly of that personal representative, then it usually can take anywhere between a couple weeks to a month for that person to actually have approval from the court to act. How long that takes really depends on how quickly people get their approvals back. If they don't receive all of the approvals back by usually that month timeframe, the court will set up a hearing and will allow people to appear to show why this person hasn't been approved or why they're objecting to it. A lot of times in my experience, when that happens, that hearing happens, it's not because anybody's actually objecting to that person being nominated. It's more because they're not getting their approvals back. And so it is often a couple of minutes of a phone call where we're sitting on the phone with the court and nobody appears to object, and then that personal representative is approved by the court. So it often just depends on how good people are at getting those forms back. But after that point, if there are no objections, then the court is very likely to approve that person and allow them to start acting as a personal representative. Now, obviously, if somebody does object, this takes things to a whole nother level, and kind of all sort of timing requirements might be delayed even further because you're having to go through why that person is objecting, what their claims might be, and who an alternative option would be potentially. But if the personal representative is approved, they are going to receive from the court what's called domiciliary letters. And I, summarize this or kind of conceptualize this as, think of this as like the badge of, approval that you can now act as that personal representative. You have financial authorities granted to you under statutes, to be able to pay bills, open estate accounts, do the things that you need to do as that personal representative. So once you have those domiciliary letters, that's when you can start acting and paying bills and accessing accounts and doing all of those things that you need to do. So that's usually why accounts being frozen for a month can seem scary to people. It can seem concerning, but that isn't actually as concerning as it seems, because there are other timing requirements that the personal representative has to meet and that the estate has to go through before everything can be settled. The first of those requirements, generally speaking, or one of the first requirements, is giving notice to creditors. So this is public notice to any unknown creditors. You usually file it in a publication, newspaper, online, or in print. And it's about 90 days that they have to come forward and file a claim against the estate. So you generally have to file one notice every 30 days for 3 months is kind of the general guidelines for that. So that's to any potential creditors. So if it's unknown if this person had creditors or any debts that were owed, but there could be, right? That's the whole point of that public notice. Now, if there are any known creditors, those creditors have to be given notice directly, and they then have a deadline to come forward and file a claim as well. So this creditor notice period is why it's not that concerning for accounts to be temporarily frozen after someone passes, because creditors can't demand payment before this happens, right? They're not able to come after the family members unless they've co-signed on loans. They're not able to go after the personal representative personally because they haven't even been approved yet. So it sounds scary to think, well, these bills are going to be frozen, or the accounts are going to be frozen, bills won't be able to be paid. But the good news is that, there are requirements that they have to follow as well, and they should not be demanding payment back before that time comes. Now, if the personal representative, out of the kindness of their heart or just to get something paid, decides to pay something out of pocket, then they could potentially be reimbursed for that payment if they use their own funds to do so, right? So they can submit that to the court if they do prepay something. But quite honestly, you don't generally need to worry about doing that because of these other timing requirements. Now, what can be very important as a personal representative for you to be aware of in that role is that when creditors are coming forward, you generally want to wait and see, all the way through that 90-day period. And the reason for that is if somebody files a late filing and they don't get it in time, they may not be entitled to be paid. They may not have their bill covered by that because they didn't meet their end of that timing requirement. So if you, get a filing late, you probably shouldn't pay it. You should pay the people who got there on time, filed on time. But if they received proper notice and they did not come forward in time, that's not on you as the personal representative or on the estate. It's on the creditor for not getting their filing in time. So your duty as a personal representative is actually to maximize the value of the estate. And if somebody has a bill that they come in late with that you now no longer have the obligation to pay as that personal representative, paying it actually isn't maximizing the value of the estate for the beneficiaries. So it sounds kind of counterintuitive of hey, if a bill's coming in, you shouldn't pay it. But if they don't meet their timing requirements, they don't get it in time, that's not your fault or the estate's fault. That's their fault for not filing it on time. And this does happen from time to time. It's usually like medical bills that come in late or, pharmacy bills or something like that, that they were given notice and they just didn't get things in time. They can certainly try to file it, but it's unlikely that they're going to have a stronger claim than they would have if they'd gotten it in on time. So bill paying, there is that timing requirement. You do have, creditors have a window that they have to meet. But you do have to give that notice too. And I think this is where there can be some concerns if somebody doesn't realize that they have to go through the probate process as a personal representative. They may think, well, I'm just going to pay all these bills and then just divide things up because the will names me in this role. And they need access to those accounts first and foremost as that personal representative, which requires court approval. And then the court is going to require that creditors receive notice. So it sounds like a hassle to have to go through this process, but in reality, what you're doing is just making sure you're following the right steps. And the court's not going to let you go to the next step until one is completed first. So you sort of have that guiding hand telling you, you need to do this. This is the timing requirement. This is when things need to be done. Now, beyond that, they can't give you a whole lot of guidance. They just have to tell you what you need to do. But you are going to have deadlines that you have to meet. So creditor notice, as I mentioned, that's the period of time where you're giving that notice and having those bills paid. After that's, all said and done, or kind of in conjunction with that, you're also, as the personal representative, going to have to file an inventory for the estate. And that's, what assets are part of the estate, personal property potentially. Is there any real estate, financial accounts, things like that? And what are the values of those things? Because you are going to have to keep track of what the initial estate was. And then you're also going to have to account for expenses that come out. So you want to keep good records of the bills you're paying, how much those bills were. You want to keep records of like if there's ongoing expenses for the home while the home is being sold, what those expenses are, right? It's really important to keep good records for this because you are going to have to give that inventory and that accounting to the court, and they're going to have to approve it. And the beneficiaries have a right to review it as well. They have a right to see that this was all handled correctly and that I'm getting what I'm supposed to as that beneficiary and that no unnecessary expenses were taken out or like improper reimbursements for things that the personal representative did. So you do want to keep good records for things. And I mean, one of the benefits here is if you have hired an attorney to help you do this, that can be really helpful because that's then the thing that they're helping you do the most is a lot of these kind of legwork issues, the accounting issues, keeping track of all these things, right? That's what they're doing to help you. Some of the decisions, that you have to make are still up to you in terms of whether or not the home is sold or whether or not certain personal property items are sold or go out to individuals. And some of that will depend, of course, on what the will itself says. But the personal representative is going to maybe still act almost like that executive, making those executive decisions. They have the final say, but if, they are not required by law to hire any sort of attorney to help them, not in Wisconsin. Some states differ there. So if you haven't hired an attorney, you're going to have to do a lot of this yourself. So, I mean, for my own family or any family friends would always encourage that they actually talk with the drafting attorney or talk with an estate planning attorney to see, hey, is this something that I'm going to need help with? Or quite frankly, if you just want assistance with it and don't want to do all of the accounting and inventorying and all of that, and you just want that, that advice as you're going through that process, hiring an attorney can be, very worthwhile in that endeavor. And I mean, what a lot of people are unaware of when it comes to probate is just how long this process takes. There can be quick probates, certainly. It depends on the complexity of the estate. It depends on, whether or not people are objecting to any sort of appointments or decisions that the personal representative makes, or if they're contesting the will, right? All of these things can, stretch this process out much longer because all bets are off at that point. You don't have just set deadlines anymore the same way you would if nobody's objecting to anything. But assuming things are going relatively smoothly, on an average basis, you might see anywhere from a year to a year and a half for probate start to finish. Now, that doesn't mean all the accounts are frozen, that disbursements can't go out sooner. It just means that from the time that the will is filed to the closing of the estate, it can on average take about a year to a year and a half. And that's the window that the court itself often gives when you see like closing dates that they suggest to the estate or put as deadlines initially, unless they are extended. But, as with anything, an average is an average, and you might see probates go much longer than that. You might see them relatively short and quick, assuming people are getting things in time. It really does depend on the complexity of the situation. And, again, like I said, if people are objecting to things, that's going to stretch that out much longer than it would otherwise need to be. I've heard stories of probates taking longer than that year and a half, sometimes longer than a couple years. That would be way outside of the ordinary and shouldn't generally be the case, but there could be reasons why that was happening in that circumstance. So don't expect this to be a quick month-long or month-long process. It's going to take some time. And so I think what you need to know as a personal representative, especially if you're not acting yet, but if you've been nominated, is this a commitment that you can potentially make? And when you are nominating someone as a personal representative, that's another thing you want to think about too, is, does this person I'm nominating, do they have time that they can take to do these things? Because it really is sort of like, a part-time job at least, that you're asking them to do. Now, personal representatives need to know that they can take fair and reasonable compensation for what they're doing too, so they can be reimbursed for their time. That is not necessarily a set amount or a set percentage that they can take. It really does depend on what they're doing, how much they're involved. My advice to clients is always, if you're acting as a personal representative and you're doing all the work yourself, you can probably take a higher fee than if you are hiring that work out, you're working with other people, and you're just making executive decisions, right? You're not doing as much work, and there's added expenses for the estate then that are sort of offsetting what your cost would be. But there's no real strict guideline on that. It's the standard that is used to determine how much a personal representative can take as compensation is that it must be fair and reasonable. And that if that sounds vague, it's because it is. And it completely depends on what that person is doing, on how much time they have involved, on the complexity, right? You'll see sort of an average suggestion of around 2% as a personal representative's fee, very similar to like what you might see as a trustee of a trust, for example. And that's generally probably fair and reasonable, but there could be definitely outlier situations where maybe that's way too high, or maybe it's not high enough too. But yeah, we don't have a statutory maximum in that sense. Now, as the personal representative, there is different processes that you might have to go through depending on what type of probate you're going through. So there is formal probate, which is what a lot of people maybe think of as probate, where you're in court in front of a judge, potentially testifying in certain circumstances if there's disputes, right? That is actually relatively rare, thankfully. It tends to be formal probate. If there are objections, it'll automatically bring it into formal. If somebody's objecting to the will or objecting to a person being nominated as personal representative, that can automatically bring it into formal probate. But most of the time, probate is actually informal probate. And that is sometimes kind of jokingly referred to as kitchen table probate, because you could be doing all of the work on your kitchen table and you just electronically file things with the court. And that is by far and away the vast majority of what we go through with probate. Now, it's important to know whether or not that the will you are nominated in actually approves that or not, because it should say whether or not the will is requiring formal or allowing informal probate. But assuming it is allowed, and assuming that nobody objects to things, you don't necessarily need to be worried about like appearing in court all the time. That is, again, relatively rare. Now, if you are an out-of-state personal representative, so meaning if it's a Wisconsin will, a Wisconsin probate, that's where the person passed away, and you live in California, for example, one thing you might need to be prepared for is Wisconsin doesn't love out-of-state personal representatives. And what I mean by that is that you can say that you don't require any sort of bond to be paid by the personal representative in your will. What that usually means is that the personal representative then doesn't have to put any money forward to act. They don't have to like have any stake in it, because you are, as the person signing the will, you don't have to require it. There are circumstances, though, where if that personal representative is out of Wisconsin, they don't reside in Wisconsin, that the courts still sometimes require that. So it's not to say you wouldn't get that money back. It's just that you need to potentially put some money forward to show, hey, if I'm not doing what I need to do, if this is costing the estate money, if I'm missing deadlines, things like that, that I could have a stake in this. And that is really there to make sure people are getting things done. So it's one thing that is thankfully not a huge issue all the time, but it's something that I caution people on if there's out-of-state personal representatives being nominated. If they have a co-personal representative who is in the state of Wisconsin, that can potentially alleviate that issue. But quite frankly, nominating co-personal representatives can lead to its own issues unless people get along really well, unless they have independent authority to act. It can just become harder to deal with in that circumstance. So I'm not seeing any questions, but and I know I went through some of that pretty quickly, but probate is a complex situation, a complex topic to go through, and it can vary in how complex that situation is, or how long this process takes, how much it costs to go through probate, depending on a lot of factors, assets, being part of it in terms of like what types of assets there are. I mean, not just how much, whether there's objections or contests going on from beneficiaries. Those are things that you need to be aware of, as factors, because they can change how much things are costing or how long it's going to take. And when you see the cost of probate, you'll generally hear figures mentioned in the neighborhood of like 3 to 5%. Now, it's not quite as simple as that. It ranges quite a bit. It has to be based off of a variety of factors, but you could expect within that range pretty consistently. And so it's an expensive process to go through as well, but just be prepared for that. It's a process that can be necessary depending on the type of estate plan somebody has. And if all that they have is a will, if all that individual has is a will, then probate is very likely to be required, depending on how they hold their assets. Just be prepared for a variety of things. One thing I forgot to mention earlier, but I would really strongly encourage any personal representative to be aware of is, depending on how the wills are written that you're nominated in, when you are looking at who the beneficiaries are, or how they're inheriting, you want to be aware of whether or not they have any unique concerns in terms of their own life. Are they on Medicaid? Are they on any other means tested assistance, meaning they can only have so much? Do they have a substance abuse issue, right? Are there any other concerns? Because depending on how the will is written, you might have the ability to protect that person from losing their benefits or having access to funds if there's a substance abuse concern. Not all wills are the same in that sense. So you want to be aware, you want it to be explained to you. And this is, again, where having an attorney help you with that can be very beneficial. Oh, and I do have one question that came in. The percentages I'm talking about, like that 3 to 5% or the 2% for the reasonable PR fee. What is that a percentage of? And that is a percentage of the value of the estate, generally speaking. So value of the estate here, meaning the assets that are actually subject to probate. So if somebody has a probate estate of $1 million, let's say that could be a $20,000 personal representative fee or compensation. That 3 to 5% could be $30,000 to $50,000 in fees, right, or expenses. Now it depends on what that actually ends up being, because that is based off of the probate estate value. Now this is also actually brings up a really good thing that personal representatives should be aware of, is that not every asset that somebody has is actually going to be subject to the probate process. So you need to know what it is that you actually have authority over. When we're talking about what assets would be subject to probate, those are assets that aren't owned, for example, by a trust. If that person had a trust and that's what owns those assets, that's not going to be subject to probate. If it's an asset that was jointly owned with another individual, like a child or a spouse or something like that, if it's jointly owned on a bank account, for example, that goes, generally speaking, to the surviving owner, and it wouldn't be subject to their probate estate. And very similarly to that, if somebody has payable on death, transfer on death, or other sorts of beneficiary designated assets, those also won't necessarily be subject to probate and might transfer directly to those individuals listed. Now, one point of caution with those is I'm not recommending that if you have a will, you just beneficiary designate everything, because as the personal representative, then that person may not have direct access to funds to pay expenses, especially if they aren't otherwise a beneficiary. So just because probate can be a longer process, that it can be expensive, doesn't mean you should avoid probate with all of your assets. If you have a will trying to appoint somebody in charge of the estate, giving them the authority to pay bills, making sure your intended results are, what actually ends up happening. So with wills, if you don't necessarily want to beneficiary designate all of your assets, and it's not a blanket, everything needs to go through probate or it should all avoid probate statement. It's just, you need to know what type of estate plan you have and how your assets would, be impacted by going through probate, or what would be better to go through probate than other types of assets, right? So yeah, the fees are based off of the probate estate, though not necessarily like everything that person ever owned, if it all just went outright to somebody through a beneficiary designation. But that being said, it's not my recommendation to just have everything avoid your will and go outside of probate, because if things are not subject to probate, then the will actually doesn't have any control over them. So it's important to know that if you want your will to work the way you intended, it might be worth discussing with your attorney, how certain assets would be better off going through probate than others and what they'd recommend. Because again, there are some things that you don't necessarily want going through probate, but other things where it would be important to, have accessible to the personal representative. And I'm out of time here, so I will let you guys go enjoy the rest of your day. But thank you all for joining me. And just a quick reminder that if you'd like us to reach out to you to set up an initial consultation, please fill out that feedback form and let us know. And that is complimentary. Again, it's scheduled for about 2 hours, so it doesn't cost you anything to come in and talk to us initially. We can usually quote you a fee by the end of the meeting on what our recommendations would be. And again, we don't have a webinar next week, so everybody enjoy their holiday. And then the following week, we will be in person for our public seminar. So I hope to see you guys in person and enjoy your